Good afternoon. It's getting a little late. I just wanted to run over something that may help some people think of these things if they are going to an ALJ hearing and the shoe fits. It was brought up by a viewer who it was very insightful. I would only really expect it from maybe someone who's practiced. So I don't know if the viewer is a practitioner or not. Could be, and just like, trolling around. And I totally get it. I totally appreciate it. But this was the issue. Sometimes for established mental, medically determinable impairments that are recognized by an ALJ as being such, so they pass that minimal test. And so it's like a diagnosis that's been properly diagnosed. And there are effects or limitations stemming from that make it severe. Effects on any one of many tasks the SSA looks at to determine someone's functional capacity to do work. It's like work-related tasks. One of the tasks that is needed for, I believe, every job out there, and as you know, we talk about there's 12,000 jobs, and we have to carve out all 12,000 essentially in order to prove that one is disabled from doing any work full time. So if a person has a mental health impairment, illness, condition, whatever you want to call it, that prevents them from reliably at any time of a day interacting appropriately with a supervisor on supervisor things. For instance, adequately responding to criticism by a supervisor, adequately responding to a supervisor, telling them to stop what they're doing now and go over there and do something else. It could be anything that a supervisor might have to relate to a subordinate. So there is the way they look at these things, the ability to interact with generally it's supervisors, coworkers, and the public, but they're very different. Someone who can't interact with the public, and sometimes it's an anxiety thing, can usually or often, nonetheless, interact with coworkers, at least to some degree, and supervisors. Now, what about when a fact finder, and say it's an ALJ, finds that the person, or throws out an RFC to the vocational expert, that the person can only occasionally interact with supervisor. Occasionally in the SSA world means up to 1/3 of a workday. So I look at that as being up to 2.5 at least hours, right? So, is it 2.5 hours in one stint, or is it sprinkled throughout the day, which means every third minute, 20 minutes at every hour, however you want to look at it. I mean, this is how the vagaries are that we have to deal with. So if a person is limited, and the evidence obviously is there to suggest that if a judge is going to throw it out there as the RFC, perhaps even in his decision, that a person is limited to occasional supervisory interaction, then I swear the little dog in the house is whining at the door. Hold on. Okay, I just told him, no. We'll see. He's outside my door, but I can hear him. He's a miniature Australian Shepherd. Don't get me started on the big mistake of COVID brain fog my husband and I engaged in for our adolescent children at the time, getting too many pets, including dogs. Anyway, okay, I'm living with the repercussions though, because that's my responsibility. Okay, so going back to it. So judge says, So let's say it's to the vocational expert, because that's where you can throw in some questions. After the decision is down, you can't really throw them into the judge. But if the judge says the person, has this medical hair, and when he does the RFC section, says, if the person is limited, in addition to being sedentary, light, or medium, or whatever he's going to say, is limited to only occasional interaction with supervisor. Are there any jobs? Vocational expert throws out 3 jobs that only require occasional interaction with a supervisor. I mean, I believe many of those jobs exist where it's only occasional interaction with a supervisor, for sure. But this is the question. And the viewer that posted this, and it's in one of the comments on some other video, but it was very astute, because I use this all the time, but not, and more recently. So I'm just kind of feeling it out to see how well it's taken. So far, my cases have, they go pretty well. So I never know exactly what made it happen. But here's the deal. If I ask the vocational expert, well, okay, so if a person can only occasionally interact with the supervisor, can that employee pick and choose when those supervisory interactions will occur? Or does the employer decide, the supervisor? And of course, we all know that an employee does not dictate when the supervisor can come speak to him. Can you imagine? It's just ludicrous. So on the times when this particular RFC has come into play, and of course, it's not all cases, maybe not even most, the VE invariably says, no, the employee can't pick and choose. So that begs the question, if the employee can only occasionally interact with the supervisor, and the supervisor is going to be picking, let's say the supervisor is picking half the time. Imagine how many times, so 2/3 of the day, the employee is not capable of appropriately interacting with the supervisor if he can only do it 1/3 of the day, right? That leaves 2/3 of the day where he cannot. So the chances of the supervisor picking a time that is, off limits because the employee is limited to only occasional, and it's obviously it's subject to his mental state, not a time clock. So I guess it begs the question, well, then there's going to be a lot of times when there's inappropriate interaction by the employee with the supervisor if 2/3 of the day he can't do it, right? So it's something to consider if you have this in an RFC proposed by a judge at your hearing and the ALJ gives jobs. Maybe give some thought to inquiring about, the amount of time the employee cannot appropriately interact with that supervisor who dictates the time, at least half the time, will be approaching him. And I've also heard vocational experts, when asked, well, how many times can an employee lip off to a supervisor before he gets canned? I've had some say, oh, one bad lip off could be enough to get someone fired. So then the question is, well, what about 2, 3? For sure, would they surely be then? Like if they're saying it may or may not at 1, well, what about 2, 3, 4? Because if a job requires occasional interaction with a supervisor, that means daily interaction with a supervisor. If 2 out of 3 times, it's not going to be a good time, very quickly you're going to get to even 4 inappropriate interactions, by the way they define it themselves. So it's something to think about. It's a kind of a fluid subject right now, but I think it's worth bringing up potentially when they say he's limited to occasional. I mean, that's what they say when someone has a real bad, it could be anger management issues where they lip off. It could be severe anxiety where they have panic attacks. They can't speak. They're going to get tearful. They run to the bathroom. It could be, lipping off, telling the supervisor, refusing to do what a supervisor says, because sometimes there's a kind of disorder where you always think you're right and you're not even going to take it from the person who you are you're being paid to listen to. You know, it's insubordination. So I think it can be a humdinger, you know, for those that have the medical evidence in the file. It could be impulsivity showing up. It could be legal issues and fights, already getting into fights. If there's a history, like in the function report, and you know, I'm all about the function report. If there's when you doing the function report, you come across a question about, have you ever been fired for how you get along with people on the job? That would be where it's time to say, if you've been fired due to arguing, fighting, being insubordinate, being snooty to your boss, that's where you want to put it. Don't be shy. Some people, like, I get the sense, might not want to put it down. No, it'll help you. So, and it's necessary, because if that is the problem, you know, if someone that lacks impulse control, has no filter on their pile, you know, this is stuff that gets us fired. And if it's stemming from a mental disorder, which again could be anxiety, could be PTSD, you know, things are handled differently, and they're controlled differently and not as well. So that is just one thing that I would bring up in a hearing, cross-examining the vocational expert, if in fact there was an RFC suggested by the judge in his hypotheticals, with only occasional interaction with a supervisor. It might not work with coworker or the public, maybe the public, because if you think about it, well, if it's a job that doesn't deal with the public, it's no harm, no foul. If it's a job that does deal with the public, really, so 2/3 of the time he's going to blow off at the, you know, if the public happens to be around, he's going to not be able to interact with them appropriately. The public is generally customers or goodwill, like it affects a business. So having an employee not be able to do that is not the person that should ever be around the public, I would say. And so you got to pose the question to the VE in a way that there's no alternative but to concede that, well, yeah, I mean, basic questions like, if a person has a capacity limited to interacting with a supervisor only occasionally, that's a third of a day, right? Yes. Is that about 2.5 hours? Up to 2.5 hours? Yes. Okay, so that means how many other hours are left of the day? Like 5.5? Yes. 5. I mean, it doesn't even matter. So 5 hours a day, the person cannot interact with the supervisor. Do we know when those 5 hours are? Is he allowed to say, no, I can't talk to you right now? Come see me later. Meet me in the office. I mean, so it's the kind of thing you probably want to prepare how you're going to do it. I'm sure everyone does it differently. You might want to have a little, you know, practice the script of sorts that you're going to decide how you say it and make it your own. But I think it's a really good point. And I don't know yet which cases have, if any, have been won on that basis. I haven't used it that much because I haven't had that RFC. I mean, it's, you know, all the RFCs are different, but I wouldn't be surprised potentially if, even if it's not what's hanging, it's not the one that's going to be relied on in writing, because that could really be changing the landscape of a lot of cases. It might, in a particular case, in a more esoteric kind of way, have a judge decide he's going to award. He might do it on a different basis. But part of the job, I think, is showing a judge why this person needs to be awarded, even if some of the reasons are not the ones he's going to emphasize in his decision. If a judge wants to award because he thinks the person's disabled, he's going to use the things that will hold the most water and that maybe he doesn't get a spanking for. I'm thinking, he or she. So, you know, part of the job is, I think, persuading a judge that this is a disabled person. And sometimes the judge will have other reasons that you're not even pushing, that he thinks he can use to award. And so once you've, convinced the judge that you're right, that the person's disabled, the judges, they want to award the disabled people. I have no doubt about that, about any judge I've ever been in. Whether there are times when we don't see eye to eye and they don't find it possible, or don't find that the person is disabled as I know the person to be. And that usually is because the medical evidence is just not there as much as we would like. By and large, they're trying to do the right thing and, award the people that really can't do any other work full time. So the more we can get them to see that that's the case, even if it's not the ones that they're going to hang their case on in terms of the written decision, I think that's part of the job. Okay. I just had to get that out there because the viewer put it up today and I thought it was great. I mean, if he's not a practitioner, he should be, because he was very articulate. He spoke like a practitioner. So I really appreciated it. So anyway, thanks guys. Bye.